Good morning, and thank you for joining the webinar. My name is Phillip Kruger, and I'm a director in the legal department of RSM South Africa, based here in Johannesburg. Today, we'll be discussing the Companies Act Amendment Acts and highlighting the most pertinent changes in the legislation. Unfortunately, we are not going to be able to cover all of the amendments envisaged in the Amendment Acts due to our time allocation, but I do intend to highlight the amendments most likely to affect companies and boards on a day-to-day basis. Additionally, I don't think there'll be time for a question and answer session during this allocated time period, but if you do have questions, please feel free to put them in the chat. Our team will collate them and send them through to me, and I will answer them via email shortly after. Great. Then, without wasting any time, why are the changes in our Companies Act 71 of 2008 necessary? Well, as we can see, more than a decade has passed since the commencement of the Companies Act, and certainly a lot has changed. We've been through 2 iterations of the King Report on Good Corporate Governance, with significant amendments brought about by King 4, particularly looking at directors' liability and the disclosure of remuneration. Compliance requirements have become extremely difficult to navigate, and the cost of compliance administration has become a significant financial burden on companies. The Companies Act itself has also shown inefficiencies in practice, in particular in respect of the requirements relating to intercompany loans. As such, 13 years on, amendments to the current position had to be made. This resulted in the 2 Amendment Acts being signed into law and being published in the Government Gazette. Although the Amendment Acts have been signed into law, there has not been any confirmation as to date of its commencement yet. As such, we await clarity in this regard. So with the background in mind, the objectives of the Amendment Acts have been stated to be as follows. Firstly, to enhance transparency and disclosure requirements. Secondly, and much to the dismay of insurers in respect of prescribed officers and directors insurance indemnity, the extent of time bars for making application to declare a director to be a delinquent director, and the extent of periods under which directors can be held liable for damages and loss. And then to reduce the administration and compliance burdens in respect of entities. And of course, lastly, clarification of technical and general cleanup of wording and problematic sections. So looking at the application, as we can see, as far as application goes, it applies throughout all types of companies, including public companies, state-owned companies, private companies, NPCs, as well as CCs. So in respect of our first amendments, these relate to definitions that have now been included in the Companies Act. And in my view, none of these bring about dramatic intervention. A definition is inserted to define the Broad-Based Economic Black Empowerment Act, as well as then a definition in respect of the Triple BEE Commissioner. And both of these are very generic and merely are added as a result of the wording being referenced in the Act. Notably, though, the definition of securities has been amended, and particularly to delete the previous vague reference to any other instruments when it refers to instruments that are viewed or deemed as securities. Now, this vague reference to any other instruments in the previous wording certainly did lead to some interpretations that could be clumsy and led to uncertainty. So in this regard, the deletion of that phrase is a welcomed amendment. First real amendment of substance, though, comes in the form of Section 16(9)(b) of the Act. Now, generally, uncertainty reigned supreme in respect of the meaning of the word filed as to when it came to an MOI amendment and when that amendment would take effect. This despite the fact that the word file had been defined in the Act. So there were different schools of thoughts. Arguments and interpretations ranged from the dates that SIPC would have received the MOI amendment, or the date that SIPC applied its mind. And there were also some non-binding opinions and guidance issued by SIPC in this regard. But ultimately, Unless a specific date was inserted into a notice of amendment, there was no absolute certainty as to when an MOI amendment was effective from. However, the amended Section 16 sufficiently clarifies this. It states very clearly that an amendment is effective 10 business days after the receipt of the notice of amendment by SIPC. Now, unless this amendment is either approved or rejected by SIPC prior to the expiry of the 10 business day period. So ultimately, the 10 business day period is the absolute outside date of which your MOI amendment could be deemed to be effective. Now, there can be a later date or a specific date set out in the notice of amendment as well, and perhaps that is still a recommended approach. In addition, though, if your MOI amendment is rejected within this 10-day period, a further insertion in the wording is that SIPC is required to provide a clear reason as to why the MOI was rejected, which results in even more clarity with regards to MOI amendments. Therefore, this amendment, in my view, is certainly a welcome addition to the section. Our second amendment relates to Section 25 of the Act, and more particularly Section 25.3. Now, this required that a company file a notice of location detailing the location at which company records would be held and be accessible if it was different from the company's registered office. The new requirement, however, in addition to the filing of this notice of location, places an obligation on SIPC to publish as prescribed the relevant notice of location filed by the company. Now, this is certainly an interesting decision by the legislature as to how this publication will take place, or when it will take place for that matter. We can really only guess. There's no clarity provided at this stage. One would assume it could be through websites, newspapers, or perhaps even a specific database that SIPC will maintain in this regard. But we don't know. So we await clarity for that to be provided from SIPC in this regard. Now, the amendment in Section 26 of the Amendment Acts constitute quite a significant departure of the previous position under the Companies Act. However, the first part of it, relating to the amendments in Section 26.1, mostly relate to clarity of wording. It provides that shareholders or persons who have a beneficial interest in the company would have the right to request annual financial statements as a separate subclause, as opposed to the combined provision in the previous Act. The previous Act would have referred to reports to annual meetings and financial statements, as mentioned in 24.3c1 and 2. The new section, however, separates these two out. The reports to annual meetings, then, as mentioned in 23c1, and the financial statements as contemplated in Section 23c2. There's also a new addition that has been included, and that is to provide the right to inspect a copy of the beneficial interest disclosure register by shareholders, or to shareholders or persons who have a beneficial interest. Where it gets more interesting, though, is in respect of Section 26.2. Now, this provides a significant departure from the previous position. For the sake of clarity, Section 26.2 relates to persons who are not shareholders and who do not hold a beneficial interest in the company, therefore essentially third parties. Previously, such third parties had a right to request access to the MOI, which is a public document in any event, the share register, and the register of directors. However, this list has now been expanded in the amendment to Section 26.2, which now adds to this list the right to request access to the annual financial statements of a company and the register of beneficial ownership. Now, in light of the recommendations of the Financial Action Task Force and the subsequent grey listing of South Africa, and therefore also the resulting necessity to disclose beneficial ownership in entities, one could perhaps understand the logic in the right to request the access to the register of beneficial interest. However, the right to access to the annual financial statements of, in particular, a private company seems to my mind to be quite invasive. To this end, the legislature did insert a qualifying provision, limiting the application of the amended Section 26 sub 2. Now, this qualifying provision states that this right to request access to the annual financial statements does not apply in respect of a private company, non-profit company, or personal liability company when, firstly, an annual financial statement is internally prepared in the company with a public interest score of less than 100, or secondly, an annual financial statement is independently prepared in a company with a public interest score of less than 350. However, in respect of private companies with a PI score of 350 or more, the amendment in Section 26(2), as it currently reads, applies. Therefore, it's recommended that these companies monitor their PI score very closely in order to ensure that they know what their compliance score requirements in respect, or their compliance requirements in respect of Section 26(2) will be. The next amendment relates to Section 30, which finally confirms the interpretation of SIPSI, IRBA, and most audit firms in respect of the disclosure of remuneration requirements relating to directors and prescribed officers. The amended section now clearly states the following: remuneration as defined in subsection 6 and benefits received by each individual director and prescribed officer in the company, both of whom must be named, must be included in this disclosure. Now, this confirms it's an individual disclosure, so the argument of the so-called categories of disclosures of directors and prescribed officers cannot be followed. And it also confirms that the person must be named in the relevant disclosure in the AFS of the company. So the arguments raised in respect of Director A, Director B, prescribed officer 1, 2, and 3 won't hold any muster in terms of the new provision. There's also a new Section 30 sub 4 that has been added, 30 sub 4 capital A, and that excludes certain sections of what is called the Director's Remuneration Report from being subject to audit. In particular, the background section and the compliance or the company policies section. Now, this we'll discuss in more detail when we come to the amendment in respect of the insertion of Section 30 capital B. But for the current purposes, it serves to be noted that this requirement is limited to public companies and state-owned companies. Now, similarly, there's a new insertion in terms of the Amendment Acts, and that is Section 30 capital A. Again, the application of this section is limited to public companies and SOCs. Essentially, this section places an obligation on these companies to prepare and present for approval a so-called remuneration policy to stakeholders at the AGM of the company, or to shareholders rather. Such a remuneration policy must then be approved by ordinary resolution. If not approved, then it must be amended and resubmitted either at the next AGM or at a shareholders meeting called specifically for this purpose. The policy remains valid for a 3-year period and surprisingly can be amended during this period without having to seek further approval. However, it is qualified to state that material amendments would require a new approval by shareholders on the basis of an ordinary resolution. What material amendments would look like, there's no further guidance on at this point in time. Now, this amendment is aligned with the disclosure requirements in respect of remuneration in King 4. However, what should be noted is that King 4 only required the approval of the remuneration policy of a company on the basis of a non-binding confirmation by shareholders. The Amendment Acts, however, have now legislated and formalized this requirement, and therefore public companies and SOCs would be required to formally produce this document at the AGM and have it approved on the basis of an ordinary resolution. Then we get to Section 30B, which we mentioned earlier. Now, again, as we mentioned previously, this insertion is limited to public companies and SOCs in terms of its application. This relates to a remuneration report, which is then prepared in respect of such a remuneration policy approved in Section 30, capital A. Now, this report must also be presented to shareholders for approval at the AGM of the entity in respect of the immediately previous financial year. The report must contain a background statement, and that we saw in the previous Section 30 Cap A will not be subject to audit. It must include a copy of the company's policy in respect of remuneration. Again, as per Section 34 capital A, it is not subject to audit, but what is then subject to audit is the implementation report with regards to the remuneration report. Now, that implementation report will have to detail the total remuneration received by each director and prescribed officer, total remuneration in respect of the employee with the highest remuneration, and then the total remuneration in respect of the employee with the lowest total remuneration. Average remuneration must be detailed, and the like. Now, there are also a number of implications that flow for a remuneration, for a REMCO ultimately, or the equivalent thereof in the company structure, if such a report is not approved at the AGM, particularly in respect of whether the members of such a committee can remain serving on the committee. So we're not going to delve into the detail of that because of the limited application of the section. But in the event that you are representing a public company or an SOC, I would strongly recommend that this amendment is well worth looking into. And it's very important that your members on your REMCO are advised as to their obligations and the possible implications in this regard. Then looking at Section 33, the annual return. The amendment to Section 33(1)A essentially just cleans up wording in respect of its predecessor, whilst not really making any substantive change to the requirements. The position remains that a company which is required by the Act to be audited must submit a copy of its audited financial statements with its annual return once this has been duly approved by its directors. The next section is quite an interesting one. This amendment relates to the new insertion of a Section 38A of the Companies Act. And this deals with a position we come across more often than one might think in practice. However, I can assure you it occurs very often. It deals with the position where the board of a company has intended to issue shares that it was not authorized to issue in the first place, or that may not even have been created in the authorized share capital before it is issued. Now, previously, as a result of a prior amendment, Section 38 of the Act, which currently still remains valid, provides for the potential retroactive authorization in accordance with Section 36 of the Act of such issued shares. Such a retroactive authorization must be attended to by shareholders, and it must be done within 60 business days of the issue of the shares. If such a retroactive approval is not provided, the issue of shares will be deemed to be a nullity. A return of value will be required by the company to the subscribing party, and there would be potential liability for directors if they voted for such an issue whilst knowing that they were not authorized to do so. However, the remedy in the current Section 38 provides only a remedy to the company, i.e. the board, the option of approaching the shareholders with a request for ratifying the issue of the unauthorized shares. However, this leaves the stakeholder or a party with an interest in the company without any remedy. It also does not provide for a court to address the situation or provide intervention. And it's in this regard that the inclusion of the new Section 38 capital A is welcomed. Section 38 capital A states, where a company purports to create, allot, or issue shares by virtue of any provision of the Act, the MOI of the company, or any other law, and where such creation, allotment, or issue is invalid, or the terms of that allotment or issue are inconsistent with the provisions of the MOI. A court may, upon receipt of an application made by the company or by any party who holds an interest in the company, and after satisfying itself that it's equitable to do so, make an order validating the creation and allotment or issue of these shares and confirming the terms of its creation, subject to such conditions as may be imposed by the court. This ultimately then will result in a position where, after the payment of certain prescribed fees, the shares are deemed to have been validly created, allotted, and issued. And of course, it's subject to any conditions that the court may impose that it may deem just. Even though the creation of this additional remedy is a step in the right direction, what remains unclear at this point is when this remedy can be exercised, particularly given that the current Section 38 still provides for the company's board to approach the shareholders for retroactive authorization within that 60-day period. So this could potentially lead to two remedies being exercised at the same time, which could lead to conflicting results. So certainly, I think a step in the right direction, but further clarity is required as to the timing of the exercise of these rights or entitlements. Our next section that we look at is Section 40 of the Companies Act, which relates to essentially uncertainty created by the use of the phrase "to be held in trust" in the previous section. So previously, when shares were issued and not immediately fully paid up, so typically in respect of sweat equity scenarios or where shares would be paid for installments, these shares then had to be issued to a third party, and the provision used the wording "to be held in trust" and then later transferred in accordance with the trust agreement. Now, this created mass confusion because it invokes the idea that a trust as a vehicle should have been held to hold these trusts or these shares to later then be issued to the subscribing party. However, this wording has now been cleaned up, and it states that these issued shares are to be transferred to a stakeholder to be held in terms of a stakeholder agreement and later transferred to the subscribing party in accordance with the stakeholder agreement. And then for good measure, a new Section 40 sub 6 and a Section 40 sub 6 capital A has been added to clean up the wording further to define a stakeholder as an independent third party who has no interest in the company or the subscribing party, who may be in the form of an attorney, notary public, or escrow agent. Certainly, I think that clarifies the position and makes things a lot easier going forward. The next amendment relates to Section 45 of the Companies Act. And finally, as an aside, they have cleaned up the heading which previously only referred to financial assistance to directors or prescribed officers, whilst it also related to intercompany loans as well. So finally, our heading is right. But furthermore, Section 45 of the Act also aims to reduce the administrative requirements in respect of financial assistance provided by a holding company to its subsidiary companies. So previously, Section 45 required that financial assistance to directors, prescribed officers, and related or interrelated companies be approved by, firstly, a special resolution of shareholders authorizing such financial assistance. Then it had to be approved by a board resolution applying the solvency and liquidity test. And of course, there was reporting duties subsequent to providing such financial assistance to stakeholders and trade unions. This, however, led to significant administrative burden in scenarios where a holding company were to provide a loan or financial assistance to its subsidiaries. So as a result of that, a new Section 45(2) capital A now excludes the position where a holding company provides financial assistance to or for the benefit of its subsidiaries from those requirements. Now, this is certainly welcomed. However, it does serve to be noted that this provision does not extend to foreign subsidiaries. This is as a result of the definition of a subsidiary in terms of Section 1 of the Act. Now, I am not certain that this was necessarily the intention of the legislature to exclude foreign subsidiaries from this relief. but rather that it may have been an unintended consequence of the structure of such a definition. But with the laws that currently read, it will indeed exclude foreign subsidiaries from not complying with those provisions. Another section then is the new section 48 sub 8, which relates to buybacks. Now, this new section 48.8 intends to amend the approval requirements for a buyback transaction. In particular, it makes significant changes to when a special resolution is required before a buyback can be implemented. Previously, section 48.8 stated that firstly, a special resolution is required to approve a buyback of the company of its own shares from a director, prescribed officer, or a person related to them. Secondly, sections 114 and 115 of the Companies Act would apply to a buyback if it involved more than 5% of the issued shares of the company or of the issued shares of any particular class of the company. Now, the new section 48 sub 8 replaces the previous one in its entirety. And essentially, it says a special resolution is always required unless the shares are acquired as a result of a pro rata offer made by the company to all shareholders of the company, notwithstanding the fact that such a pro rata offer to all shareholders may also include shareholders who are one or more persons referred to above. So that would particularly then relate to prescribed officers and directors. Secondly, transactions effected on a recognized stock exchange, which the shares of the company are traded, being licensed as an exchange as contemplated in the Financial Markets Act 19 of 2012. So it's really only those two which would not require a special resolution. When one does look at the verbatim wording of section 48.8, in my view, it's not the best drafted provision. It is drafted in the negative. So it does take a couple of readings to get to the crux of it. But essentially, unless your transaction falls within either one or two of those exclusions, you will always require a special resolution to authorize the buyback. The next section relates to section 61.8, which has been amended to provide for 2 additional reports to be presented at an AGM of a company, if indeed the company is required to have an AGM, bearing in mind that AGMs are generally only required for public companies and SOCs. So previously, section 61.8a required the presentation of the following at an AGM: a director's report, audited financial statements, and an audit committee report. The new section 61.8a, however, requires the above whilst also adding to that list the Social and Ethics Committee report, as well as the Remuneration Committee, or the Remuneration Report that we discussed in terms of section 30, capital B. In addition, then, the members of the Social and Ethics Committee must also be appointed at the AGM, similar to the members of the Audit Committee that has to be appointed at the AGM. Then we come to the amendments to section 72 of the Companies Act, which relates specifically to committees. And in this regard, there's been significant amendment insofar as it relates to the Social and Ethics Committee in particular. So firstly, one of the major amendments is that if a company is to apply for exemption for the requirement to have a Social and Ethics Committee, this company must first publish their intention to lodge an application for exemption with the tribunal in the prescribed manner. Now, what that prescribed manner is, so far, has no light been shed on, and also there's no clarity as to where and how this publication would take place. Again, would it be in newspapers? Would it be on a website, a database, for instance? So similarly then to the previous provisions, if an exemption is granted, it could be granted on the basis that a company has a formal mechanism within its structures which substantially performs the functions of the SME Com in terms of its regulations, or it would be granted if it's not reasonably necessary, having regard to the nature and extent of the structures and activities of the company and whether it is in the public interest to have a Social and Ethics Committee. Again, the previous provisions are repeated in the amendments where a social and ethics committee is not required where a company is a subsidiary of another company that has a social and ethics committee, and that existing social and ethics committee will perform the function on behalf of the subco, or if the company has already been exempted by the tribunal, again, due to the definitions there of company and subsidiary. Please do note that the company's tribunal has previously ruled that that requirement only applies insofar as that other company is a local entity. Now, another deviation from what was previously the position in respect of social and ethics committee is that the minister may now prescribe minimum qualifications, skills, and experience requirements for the members of the social and ethics committee that he or she may consider necessary in respect of having membership of that committee. Now, this was previously not the case in respect of the members of the social and ethics committee, and a close eye will need to be kept on any such determinations made by the minister in order to ensure compliance as to the members of the committee. And sadly, this may also create additional difficulty in finding the relevant skills for membership of such a social ethics committee. In the case of a public company, an SOC, the requirements for membership has changed in the sense that the majority of the members must now be directors who are not involved in the day-to-day management of the business of the company and must not have been so involved at any time during the previous 3 financial years. In respect of private companies and other companies that may require a social and ethics committee, the requirements remain the same, being that it consists of not less than 3 directors or prescribed officers, at least one of whom must be a director who is not involved in the day-to-day management of the business of the company and must not have been so involved for the previous 3 financial years. Our next amendment relates to Section 91 capital A of the Act, and it really addresses what was previously an oversight in the Act. Previously, the Act required that a private company referred to in Section 84(1)(c) sub 1, or a company that is required only in terms of its memorandum of incorporation to have its annual financial statements audited, it had the requirement that it had to appoint an auditor at an AGM. Now, the requirement to have an AGM generally applies to public companies and SOCs, and therefore the previous position contemplated an unnecessary requirement for a private company to hold an AGM purely to appoint the auditor. This has now been rectified by the new section. It states that a company referred to in Section 84, or a company that is required only in terms of its MOI to have its annual financial statements audited as contemplated in 34(2) and Section 84, must appoint an auditor at a shareholders meeting at which the requirement first applies to the company and thereafter annually. Now, this clarifies the position and I think provides quite a bit of relief in respect of the previous onerous requirement. Furthermore, there is also an insertion of a new clause 92B5. And this relates to the previous term of 5 years prohibiting specific parties to act as an auditor of the company. That period has now been reduced to 2 years, and this amendment is certainly welcomed by particularly in the audit fraternity. The next section then relates to Section 77 sub 7 of the Act. And this section has the effect that the general prescription period of 3 years does not necessarily apply to the liability of a director. In the event that such a director is guilty of an act or omission that gives rise to damages or loss. Now, if we look at the section, it says that the Prescription Act does not apply to this position. It then goes on to say that such proceedings may not necessarily be commenced with 3 years after the act or omission that gave rise to the liability, but a court may on good cause shown extend the period. And that applies irrespective of whether the 3-year period has expired or not. And it also applies irrespective of whether the act or omission that caused the damages or loss occurred prior to the promulgation of the Amendment Acts. So it strikes towards being applied retrospectively, which is actually quite scary in this instance. Similarly, then, the amended section 162 creates the position where an application can be brought against the director to declare them a delinquent director. In terms of the previous position, that director that the application is brought in respect of had to have been a director of the company for the immediately previous 24 months at least. That period has now been extended to the immediately previous 60 months preceding the application, therefore casting the net for applications to be brought in respect of directors much wider. Now, the new section 162 sub 2 to capital A also says that the court may, on good cause shown, extend that 60-month period even further, regardless of whether that period has expired or not, or whether the circumstances occurred prior to the promulgation of the Amendment Acts, again, applying retrospectively. So definitely two sections to be aware of as directors. If you do serve on boards on companies, it certainly does have an increase, a factor increasing your risk in that regard. Then we are nearly at our time limit for our session. Unfortunately, it was only 30 minutes. However, I just want to run quickly through remaining amendments that we couldn't cover in this session. However, these amendments relate to situations that they would apply in only limited circumstances. So I do believe they are not necessarily sections that we have to cover in this session. So section 95 is one of those remaining sections. It relates to public offerings. Then particularly the employee share scheme definition has been amended. Secondly, section 118 has also been amended, particularly relating to the takeover regulations. And then in particular, the application to a private company and when those takeover regulation provisions applies to a private company. Section 135, the business rescue provisions have been amended, particularly in respect of post-commencement finance relating to costs of a lease. Section 160, disputes concerning name reservations, has been amended. That relates to administrative orders. Section 166, alternative dispute resolutions, has also been amended, and that relates to process requirements. Section 167, dispute resolution consent orders, has been amended. There it mostly relates to a cleanup of the wording. Section 194, appointment of the company's tribunal, that mostly relates to administrative requirements. Section 195, the functions of the company's tribunal, again, administrative amendments have been made there. And then lastly, Section 204, the functions of the Financial Reporting Standards Council, has been amended as well. Now, with that all said, just a couple of thoughts in respect of the Amendment Acts in general. I think on the whole, barring maybe one or two provisions, the amendments are positive, and they certainly do seem to clarify a number of interpretational issues that we have previously grappled with. There are certainly items that require clarification, particularly clarification from SIPSI and the legislature as to how it will apply and possibly even court interpretation. But again, on the whole, I think a step in the right direction. And certainly many of the objectives listed in the beginning of this presentation has been achieved by the legislature in the Amendment Acts. So with that, I thank you for your time. Again, if you did post any questions in the chat, we will be certain to address them for you. Thank you very much and have a fantastic day.